Hello, members. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everybody. And today we are diving into both constitutional law and administrative law, and we shall be looking at the principles on the law of rule of law. We shall see what the concept of rule of law means, how it has been in application, and what are the prerequisites or the indicators of the law of rule of law and how it has been in application in Uganda. Without further indulgence, I'm Council Ben and let's jump right in. Well, before looking at the formal definition of the concept or of rule of law, we first have to understand it in a layman's language. In a layman's language, basic understanding of the concept of rule of law means the absolute ruling of the law. The law rules above everything. It's the highest ruling authority in a given state. Also, moving on to with authorities, we shall look at the definition of evidency who defined rule of law in his book Introduction to the Study of the Law of the Constitution, published in 1885, where he defines the rule of law as the absolute supremacy and predominance of regular laws as opposed to the influence of arbitrary power. In his definition, he highlights three main points, which are the supremacy of the law, equality before the law, and protection of rights. And that we've given authorities in our domestic laws. Secondly, according to the United Nations Security Document of 2004, under Section 616, Paragraph 6, the rule of law is defined exactly as the principle of governance in which all persons, institutions, entities, private and public, including the state itself, are accountable to the laws which are legally promulgated, publicly adjudicated, and enforced by that country, and which respects the standards and norms of international human rights. Thirdly, we can also use the judicial definition in the case of Uganda Law Society versus Attorney General, in which the court defined rule of law to mean that all authorities and public officials are acting within the confines of the law and they are not acting ultra vires or acting beyond the power given to them by the law. That is what we call rule of law. So, members, here we have looked at three main definitions that we can use with authority of the rule of law, and we saw that what is the meaning of the rule of law, and now we are going to look at its applicability. Talking about the applicability or indicators of what we call the rule of law, here we are looking at what are those factors that will show us that in a given sovereign or state we have the rule of law applied. Well, this has been discussed in Geneva in 1959 by the International Coalition or Commission of Jurists, and they laid down a numbers of factors which we are going to list down one by one and explain them. So these factors are the ones that will show that in a given state, country, or sovereign, we have the rule of law applied. The first point laid out in the discussion of the International Coalition of Jurists in Geneva 1959 is what we call equality before the law. And relating to the Ugandan legal framework, we see this captured under Article 21 of the 1995 Constitution of the Republic of Uganda. And this has been in application in so many cases that we know that people applied or went to court to claim equality before the law. We see the case of Uganda Women Lawyers Association versus Attorney General, in which the court even defined equality before the law to say that equality does not necessarily mean that all people are treated in the same way, but it allows reasonable proportion of treatment. Someone will not come and say that he will claim the same treatment as the President of the Republic. So that does not mean equality, that equality means that everyone has to be treated in the same way, but it means that rights are given according to merits and certain position in the society. So that is what we call equality before the law. Secondly, we shall have the point of democratic governance or democracy in brief. And what do we call democracy? Democracy has been defined according to the Black's Law Dictionary, 9th edition under page 713, to mean what? To mean the governance in which the power belongs to the people, people power, of course. So, and this is captured under the first article of the Constitution, where they say that the power belongs to the people and shall be exercised in accordance to their will. They want to be governed in a way that they don't wish to. And democracy is a very broad topic. We cannot finish it under the points of rule of law, but we can just talk about the few features of democracy, which include, of course, elections, which is the way by which the population or the people express their voice by voting or electing the people who are going to lead them. And this is even provided for under Article 59 of the Republic of Uganda, as amended in 1995. It has been advocated for, even in the case of Mbaba's versus Yoweri Kaguta Museveni. In this case, it is a petition in which he was claiming that the presidential election, he was challenging the presidential election of 2016. So this is to show that the people in Uganda are practicing democracy to some extent. Of course, after we shall look at the extent to which rule of law has not been applied, and we shall see that to some point democracy is not upheld. Following that point, thirdly, we can talk about the supremacy of the Constitution as one of the points talked about at the discussion in Geneva 1959 by the International Coalition of Jurists. And talking about the supremacy of the Constitution and relating to the Ugandan legal framework, we shall see that it is provided for under Article 2 and say to say that the Constitution is the supreme law of the land. And under subsection 2, under clause 2, sorry, all those conflicting or inconsistent with the provision of the Constitution shall be declared null and void and unconstitutional to the extent of its inconsistency with the Constitution. This has been applied in the case of Salvatore Abuki versus Attorney General, in which the court rendered Section 4 and 5 of the Witchcraft Act null and void because of ambiguity. They were ambiguous and are violating the right to personal property and human dignity of Salvatore Abuki. And to that said, supremacy of the Constitution is one of the points that shows application of the rule of law in a given sovereign or state or country. Fourthly, we talk about an independent and impartial judiciary in a given country or sovereign. Well, here, what do we mean by independence and impartiality of the judiciary? This is provided for, by the way, under Article 128 of the 1995 Constitution of the Republic of Uganda, and also provided for in the Judicial Code of Conduct of Uganda. And judicial independence is also one of the broad topics that we cannot exhaust in this video about rule of law, but we shall just talk about the few features that can capture what we call judicial independence. And judicial independence is upheld when there is security of tenure. The judges and judicial officers have to have that security of tenure. Not to worry about, I might be in court right now, maybe tomorrow my work is going to get done and I get exposed for the judgments that I've done. So security of tenure is one of the points that shows clearly independence of the judiciary. Secondly, we can look at the adequate remuneration for the judges not to be biased by any kind of corruption or bribery. They have to have adequate remuneration, enough for them, and to give them that pride of not falling into temptation like corruption and other corruption related offenses. We can look at the adequate appointment. We know that the Judicial Service Commission has to send the names of the judges, of the people who are to be appointed as judges or judicial officers to the president, and the president to nominate them. So the process of appointment is one of the things that shows independence of the judiciary, not to be in a kind of way that will be influenced by someone who is appointing them. Someone should not appoint judges just on his free will. So this is controlled, and we shall talk about this when we are talking about separation of power, and to see that there is a check and balance when they are appointing judicial officers. But to some extent, we see that judicial independence in Uganda currently is not totally satisfied or respected or upheld, because in some cases we see maybe, for example, that by the way, in the case of Uganda Law Society of the Attorney General, where we see that the military officers coming to seize someone who has just been granted bail, and he has been granted bail, but as, even in the court's premises, he's being again rearrested, and to show that the decision of the judiciary has not been upheld, and as such, the judiciary is not independent to its fullest capacity. On fifth position, we shall look at the effective enforcement of laws in a given country or sovereign, to talk about the rule of law. And talking about the enforcement, how does a country or a sovereign or a state, a government, enforce the laws in the country? Of course, it is through bodies like the police, the army. And here, as authority, you can talk about the article that provides for the Uganda police, Article 211. You can talk about the UPDF Acts, the Police Act. You can talk about all of those authorities to enforce that point and to show the enforcement or the effective enforcement of laws in the country. Six, we can talk about protection of individual rights. And here, relating to the Ugandan legal framework, you are going to talk about Chapter 4 of the Constitution, which provides for the human rights, the basic human rights. And these rights under Article 20 are inherent and not granted by the state. The same has been held in the case of Reverend Father Mtikila Vadas, Attorney General of Tanzania. And on seventh position, we have the government according to the law, or accountability of the government to the law. And here we see that all the members of the government, or all the authorities in the government, have to act within the power that the law have given them. They have to act intra vires, within the power that the laws of the country have granted them, and not to go beyond that power, not to act ultra vires. And here we shall see, you can even talk about the IGG, the Inspector General of Government, under Article 223, whose main purpose is to render the government accountable and to look over their actions and to make sure that they maintain the rule of law and they maintain the power that have been given unto them by the law. 8. We have observance of international law. And here we shall look at the fact that in a given country there is respect of the standards of international law and respect of the laws to which the country has ratified, to which the country is a signatory, to which the country has assent, and to which the country has domesticated. So all these key terms are the ways by which a country adopts an international law. Well, you can talk about the Judicature Act, which provides for applicability of international law in Uganda and all those international instruments to which Uganda has ratified. We can cite out the Universal Declaration of Human and People's Rights. We can cite out the African Charter on Human and People's Rights. We can talk about the UNCRC, which, by the way, is a replica of the Children Act that we are using. So the Children Act directly borrowed knowledge from the UNCRC to provide for the rights of the children. On ninth position, we shall talk about the principles of administrative law. And these principles are also kind of wide, so we cannot exhaust all of them. But here it is kind of similar to the previous one, whereby the public officials and authorities are not to act outside the confines of the law. And this also gives a mandate to all the people who are aggrieved by any decision of an administrative authority to go and seek for justice, seek for redress. This is provided for under Article 42 of the Constitution, whereby every person has the right to go to court and apply for redress wherever he has been affected negatively by any decision of a public administrative officer or administrative authority. After that, you can talk about the provisions for judicial review, you can talk about the tribunals. This is all to show how administrative law is respected in a given country. So, and all those amounts to what shows the application of rule of law in a given country. On 10th position, you're going to talk about the principles of fair hearing. This is provided for under Article 28 of the 1995 Constitution of the Republic of Uganda as amended, and here it is also a broad topic that we cannot exhaust in the whole of it in this video, but we shall just talk about the few things that are provided for, the few principles under the article of fair hearing. So you will talk about the notice. Someone, when he's arrested, has to be notified, the presumption of innocence, protection against double jeopardy, and all of those principles under the article of fair hearing. As in addition, by the way, to this point, you can refer also to the other Latin maxim that portray out the applicability of fair hearing, and that is audi alteram partem in the principles of natural justice. Fair hearing means also to hear the other party. That is the literal translation of the Latin maxim of audi alteram partem. With authority, you can talk about the famous case of Uganda versus Commission of Prison, ex parte Matovi 1966 in the East African Law Report. And in this case, failure to serve notice of motion to the accused and to tell him what he is arrested for was a clear violation of the principles of fair hearing. That is to show that the rule of law was not applied. Lastly, we shall talk about existence of a strong government. Under this point, What does a strong government mean? This has been provided for under the Montevideo Convention of 1933. Under Article 1, defining what is a state and what are the prerequisites for a state to be recognized, there is a defined territory, there is application and enforcement and effective enforcement of laws, there is what we call defense on the exterior, or what we shall call the army, but also recognition on the international basis, on an international level. The state is recognized and has developed relations with other states. That is what we call a strong government. So in conclusion, guys, we shall see that in Uganda, in the current situation, the rule of law is applied or is in application to some extent because at least all of these prerequisites are provided for in our legal framework. But to some extent also, these rules or principles are only on papers, but on ground they are somehow violated. So it is, of course, subjective to everyone, but according to these prerequisites given, Uganda has applied rule of law to some extent, but due to some other circumstances that are violating these principles, rule of law has not been in application. So guys, that has been for today the topic of rule of law. I urge you to make further research, of course, on those authorities that I've given unto you, and like, subscribe, share. That is the only way we can support this initiative of Agora Legis. And I hope to see you in the next video. Thank you for watching.